Good afternoon, everybody. Well, actually, it's still the morning there. Good morning, everybody on the West Coast. This is our recorded video of the FFLGuard California Yearly Service Plan monthly gathering webinar, whatever you want to call it. Just checking in on how things are going. There's always things happening in California. The videos are watched afterwards for those who do not join with us. But we do have the important players with us this afternoon. My brother Brian, the Director of Client Relations or Client Relations Manager, is on the phone, along with our California Counsel, Sans, Chuck Michele, that being Matt Cubiero and Josh Dale. Of course, we rely on Chuck's office to shepherd us through all things California. You guys have had an active month of things happening. Why don't we just jump into Matt? You have a bullet point list of all the fun cases that have been litigated out there last month and what's going on there?
Yeah, so the big one, of course, is the recent developments in the Duncan v. Becerra lawsuit, which, if you're unfamiliar with that, that's our challenge to the restrictions on magazines capable of holding more than 10 rounds. The Ninth Circuit came out with a very favorable decision since we last hosted one of these webinars. As of last week, we have now been directed to file what's called a response to a petition for an en banc review from the state of California, challenging the Ninth Circuit panel opinion, basically. And so what this means, I think, importantly for dealers, is to understand that we're not entirely sure. However, the procedures and everything that's been made available to us thus far suggests that there is still a restriction in place on acquisition, sale, transfer, distribution, importation, what have you, of magazines capable of holding more than 10 rounds. Thanks in part to the lower court decision from Judge Benitez down there in San Diego, that is still in effect. And so that what we view that as far as dealers that are on this call, is that you should not be engaging in sales, at least at this time, just because of the questions that surround that issue. And there are reasons for that, which I won't go into too much detail, but just know that essentially at this time, what's happening is the state is appealing the Ninth Circuit decision. They're trying to get a larger, what's called an en banc panel of the Ninth Circuit to rehear the case, just essentially the same way the three-judge panel did. And so now that they've filed their petition, we have 21 days to file a response, which I believe that's due on the 18th. So not this Friday, but next Friday. And then from there, the court's going to decide whether or not they want to take the case en banc, and it's going to be at least a couple months before we have a solid understanding of where we are as far as the process is concerned. But that's just to give everyone a quick update on that, so because I know there are probably going to be a lot of questions on that. Besides that, as far as things that are going on in California, we're still seeing some issues with dealers as far as their COEs are concerned. In particular, if you are the license holder, and your COE renewal is coming up, it's kind of a catch-22 right now, in that they're requiring you to submit the application. I think it's at least 90 days ahead of time. However, the problem with the system that they've set up is they don't even let you submit the application until at least 90 days are up as far as your COE renewal time is concerned. And so they've been very slow right now, for obvious reasons, in getting those applications processed. We've also understand that you have to submit those through CFARS, the online system, and we've had some dealers that have had inability to access their accounts in CFARS, and they spend 2 months, and then finally they're able to get access to it, and then they're like 2 weeks out from their COE renewal deadline, and so of course DOJ doesn't get to it in time, and so we've had to prod DOJ on that a little bit. So make sure you guys are getting your COE renewals in as soon as possible, just to avoid any sort of hiccups, especially if you're like the only license holder because if your COE goes down, unfortunately you're unable to access DES as well as your employees are unable to access DES on your behalf. And so that has been causing some issues. But beyond that, as far as everything else is concerned, we haven't been told that dealers have been ordered to close. Everyone seems to be proceeding business as usual for the most part in light of all the COVID-19 restrictions. Of course, if something you're aware of something, please let us know. But beyond that, that's all I have for today, unless anyone has any specific questions on anything.
Raising my hand,
Yep.
Matt Cubiero. I got a side text from Chuck last week that had something to do with the California DOJ now taking under advisement the potential to fine federal firearms licensed dealers
Yes.
for violations, which for those of you who don't know, the ATF only fines dealers when there's a NICS violation up to $8,000 per violation. Otherwise, there is no fine or suspension system officially in place federally. So Matt, how does the potential for California DOJ fining dealers come into play?
Yeah, so this is actually a pending bill. This is a bill that's currently before the legislature right now to create fines for violations of California firearm laws that could result in suspension or revocation of the license. And so if you're found by DOJ to engage in any of those types of activities, and this bill does come to pass, which right now it has passed out of the legislature and is currently before the governor, is my understanding. He does have a time limit as far as when he can sign it. Of course, Gavin Newsom being who he is, I expect he will sign this, at which point this bill, being a non-urgency status bill, will take effect as of January 1st next year. And so we will, of course, once that happens, send out some detailed information around through FFLGuard to explain exactly what this means. But the bottom line is that if you are found to engage in any activity that could result in the suspension or revocation of your license, like during the course of an inspection from DOJ's field representatives, for example, in addition to facing potential criminal penalties, you could also face potential civil penalties for each violation. And I want to say the violation amounts range from $1,000 to $3,000 each. And so, of course, this is a very good time to make sure that you're paying attention to your record keeping requirements, your transfer procedures, and all of that fun stuff, basically day-to-day operations, and make sure that you've got that, down to the wire, and there are no questions or concerns with that. So,
thank you, sir. Let's punt it over to Joshua Dale.
Good morning or good afternoon, Chris.
How are you? How are you? I'm doing good. And how about yourself?
Not too bad, other than it sort of looks like we're in the seventh circle of hell here in Southern California because we have a couple fires going.
So we hear. So we hear over here.
Yeah, and that's a nice break from the heat wave we had. So I don't know if it's a nice break, but it's a break from the heat wave we had.
Gotcha.
So Matt was talking a little bit about this bill, and one of the interesting things about the bill, assuming it's signed and once it's enacted, to see if the field reps become more or less aggressive with some of their citations. I know in our experience in representing California FFLs, we've seen instances where there have been some pretty ticky-tack violations that a dealer will get cited for during an inspection. And so with the specter that some of these may carry civil fines, whether or not the field reps will be empowered to be more aggressive, and whether this will potentially be a fundraising tool, or whether they'll be less aggressive because they know there's a little more teeth if they do violate somebody for a violation. So, and unfortunately, we can't predict how that's going to go. But that leads to an interesting issue that Matt and I got a question on from a client about a month ago, which is, can you sell CBD oil products as an FFL? And the answer is that you probably shouldn't. And here's why. Although CBD, as you guys may know out here in California, recreational marijuana cannabis is now legal. CBD oil is been federally, what I want to say, descheduled, although not really, and I'll explain why in a second. But the federal prohibition about being an active user of narcotics as a and not being able to own or possess a firearm still applies, regardless of the legality of cannabis in this jurisdiction or any other jurisdiction. So if you're an FFL and you're thinking, hey, I need to expand my practice because I'm just not making enough money off selling all of these firearms. I can't get any supply from my distributor, so I got to branch out. Our suggestion would be don't try to sell CBD oil. And the reason is that although CBD oil has been what I call descheduled, it's been moved from a Schedule 1 to a Schedule 5 controlled substance. So what that means is that it's still considered a controlled substance. It just has much fewer penalties. The problem as an FFL is if you're selling something like CBD oil to customers, it potentially still invokes the prohibition. So if those customers are coming in, they're buying a firearm and they're also buying some CBD oil pills for their bad back or so they can get some sleep, the problem becomes that you could potentially have liability for not warning them, hey, by the way, if you get busted and the feds find you with the CBD oil, they may try to apply 922G. Or the local authority finds you with the CBD oil. So that was a real interesting and odd question that Matt and I got, and I thought I would pass that along to you folks who maybe are looking at ways to make a little more money. One of the questions I've been getting as we're moving through the pandemic and we're all adjusting and figuring things out is for California FFLs, can you actually require your employees to get COVID testing as a condition of being on the job or coming back to the job after a leave of absence? And the answer is yes, you can. And it's a really interesting and odd intersection of employee health and employee safety versus employee privacy and disability law. And so in normal circumstances, unless you can show that some sort of medical testing is key to a person performing the job, under California law, you can't require people to get medical testing. However, in this instance, what we're seeing is both the EEOC, that's the federal agency responsible for making sure that there's fairness within the workplace, as well as the California Department of Fair Employment and Housing, have both come out with guidelines that say it is okay, despite some of these disability accommodation laws, medical privacy laws, to require your employees to get tested as a condition of either coming back to work or continuing in work. So you can actually ask for active testing. The rub here is that as an employer, you're going to be obligated to pay for the testing unless there's some way your employee can get tested at no cost to them through their insurance. So if they go to their insurance and they got a copay, technically as an employer, if you ask them to get the testing, you got to cover their copay. If they don't have insurance, you got to cover the whole thing. So that's a little bit of a conundrum for you folks who may be concerned or trying to be a little preemptive in dealing with your employees and making sure that you have a safe workplace for your employees and for your customers. You can get them tested. So does anybody have any questions about that? All right, so let me go over a few more topics here. One question we've gotten is whether or not if you have employees that have been furloughed or they're taking COVID-19 leave, whether they can still accrue vacation or sick pay. And the answer is generally no. The one caveat to that is if you furlough an employee and then they come back after some period of time, if they had accrued paid leave, they're allowed to keep that paid leave. So whether that's in the form of sick leave or it's in the form of vacation or PTO, they can't forfeit it because they were furloughed and then they came back to the job. Let's see, what else do we have to talk about today? Scrolling down here, we've got, okay, so recently, and I say recently, this was back in June, Newsom, our governor, ended up signing an executive order mandating what your requirements are as employers when it comes to maintaining a safe workplace, and specifically with regard to mask wearing. And as to FFLs, what you guys need to understand is there are 3 specific requirements of his executive order that require you to make sure that almost all your employees are wearing masks. I know for most of you, this isn't necessarily an issue, but if you have a portion of your business that has like a back warehouse where you don't have your employees interacting necessarily with the public, you still may be obligated to require them to wear masks. So these are the specifics that apply to FFLs as to when you need to have your employees wearing masks. Obviously, when they're working in any space that involves the public, so if they're interacting with the public at all, just like you're making your customers wear masks, you have to make your employees wear masks, and it's a good idea anyways, but it's actually a requirement of this executive order. If your employees have to walk through common areas, so if you're in a business that has common areas, whether it may be a sort of a back alley area where maybe trash is distributed among the different tenants in your retail area, or if there are hallways or stairwells, elevators, anything like that, your employees have to wear masks there. And then finally, if they're in any enclosed area where they can't practice social distancing, so they can't be more than 6 feet apart. So this would be this back warehouse area I was talking about earlier. If they are unable to interact with each other and stay 6 feet apart, they got to wear masks back there as well. So those are the 3 that are going to apply to you folks. And that's all I have, other than it's great to see you all. I recently came back from taking a bar exam, and I'm glad to no longer be doing that. And I'm glad to be talking to you guys.
Which bar exam did you take?
Nevada.
Nevada. Good old Nevada.
Good for you, getting the F out of Cali.
Well, we'll see.
So with that said, I don't have I don't have access to my chat screen. Brian, is there anything other than Matt's reference to the bill that he was speaking on? I don't think anybody has any questions. So to that end, of course, everyone, please remember that you can always ask
Hold on. Kevin, are you unmuted?
No, he's muted.
Here, let me unmute you. Go ahead, Kevin. Tell Matt and Josh about this.
Yeah, so on 6th, just the last one, I was driving my daughter to college in Kentucky. Kentucky doesn't seem to be too worried about this stuff. But on August 6th, sheriff's office showed up and basically said that the County of Alameda's health department had deemed the range connected to my retail space is unessential and that we were in violation, so they shut us down. Multiple documents that they had requested on August 11th and have yet to get any kind of a ruling. We do law enforcement qualifications, we do HR 218 qualifications, guard card, we do some, so we were trying to do it based on the classes and those. Pretty much every response, my last response I got from them was pretty much, it's basically this, but it was pretty much, don't contact us, we'll contact you when we have something to say. And then the last response was, hey, we're, team's working on it, when Travis actually sent them something, I think last Monday, actually. So kind of weird how they deem us essential all the way up through when this happened, March 16th, something like that, when kind of everything happened up until first part of August, and then all of a sudden we're not. So kind of an odd turn.
Boys?
Yeah, so just keep us informed on that. But it sounds like you've gotten an initial contact from the sheriff that said you're not essential, but then you haven't actually been ordered to close yet, or have you been ordered to close and cease operations?
Well, so the main door is they say is fine, and we're in a weird, I don't know, it's been weird because the County of Alameda has been kind of heavy-handed. The city of Dublin has not, and the sheriff's office is a contract. Dublin is a contract city with the sheriff's office. So even though they're Alameda County Sheriff's deputies, they're Dublin PD in effect. When they came and talked to me, it was basically we're not shutting you down, but if you continue to operate, you're going to get fined and or you're going to be cited. So that to me is, you know, got a shut. They gave me the information, lady to contact at the county, and then basically the documentation that they need to make a ruling as to whether we can continue to operate or not. And then it just kind of stopped. I kind of figured this was going to be a relatively quick. I mean, even if they know, I mean, it's not a whole lot to this really. So yeah, so that's kind of where we're at.
Okay. I'd say just keep us updated on that for now. It sounds like you might have gotten contacted by some low-level deputy or enforcer that made a determination, and they're not quite so sure. But I mean, let us know if something changes, and of course, we're happy to take a look at it in more detail if you want to send us any of the communications that you've received thus far. Have you actually received like a written demand or anything like that, or was it just a sort of like a knock and talk from the sheriff deputies?
So knock and talk, and it wasn't. So it was a sergeant that I talked to. He's part of the I don't know exactly what they call their unit, but it's kind of like an outreach. They're not assigned a beat. They just kind of go around, and not COVID necessarily. They were doing that prior to, kind of like crime prevention unit type thing. What it sounded like to me was they were contacted. They, meaning the city of Dublin, was contacted by the Alameda County Health Department. I guess there was a meeting between the police chief, the city manager, and Alameda County. It sounded like they came down on Dublin saying, you got to put an end to this. It is kind of the impression I got while talking with the officers. So yeah, it wasn't Dublin actually has been very good. The city itself seemed to be good, but it jumped them to the county, and the county in Alameda has been less than cordial, especially to gun shop owners, from what I understand.
Yeah, let's take this conversation offline. We can talk about it in more detail, but okay, I get the gist of it now, but we should talk a little bit more.
So just before we...
Do you see Jeff's note, Chris? Jeff Perry? Jeff wants to know, because Brinks has a range out in Oakland, which I assume is also Alameda County, but they use it just for them. It's for Brinks, Matt. It's just them, their employees.
Well, I mean, bottom line, if the range, if the range that's at issue here hasn't been contacted, then the problem is the existing orders from Alameda County, I believe, are not specific to shooting ranges. And so what you're getting are these varying interpretations depending on who's enforcing what. And so it's one of those things that we'll look at. But I would say if you haven't been contacted or told to shut down, you're probably okay for now. But I'll take a look at the Alameda County Public Health Order to see if there's anything specific, which I doubt as applied to shooting ranges.
So with regard to guns, fishing, and other stuff, can we open a case in our system, Brian, for this particular issue? And Matt, can you send a letter saying WTF?
That's one of the options, absolutely. But I think we should take a look at it first, and we'll talk about it.
Okay, let's just eyeball it. The guns, fishing, and other stuff are on 2 California plans, one for each store. So we should do something, and I'll work it out with you guys as to how it plays out. So other than that,
well, let me just add a little more context to Kevin's particular issue, which is over the past several months we've been dealing with these sort of on a county by county basis. Our firm has filed, as we've previously discussed, at least 2 or 3 lawsuits. Other groups have filed lawsuits. It's been very hit or miss with the lawsuits to try to enforce what's an essential business and what sort of firearms type businesses fall within that. And so to some extent, I think what Kevin may be experiencing is some emboldening of officials there in Alameda County, because like I said, it's been hit or miss. You know, down here in LA County, it was on again, off again, on again. And when we do go to court and try to get preliminary injunctions, we're finding that state court judges are very sympathetic to the county officials on this. And the problem is we just don't sort of have the run out of time to litigate this up to the point where somebody can take a legitimate stab at the constitutional or the state law preemption or whatever issue we're raising to try to challenge the unfairness of these orders. And so, you know, please contact us, please, you know, go through FFLGuard, contact us and let us know if you're having this issue in your county, because it is very much a county by county issue, and we will work to try to help you out. The political aspect of this is probably going to be the most effective in the short time frames we have before this stuff hopefully starts going away. But you know, we're going to continue to fight for you guys on this, and so please keep us in the loop when you're having these issues.
I agree. The help desk is the best way for that. Brian can sort it from there and either convert it from a help desk question to an actual monitored case. And Brian is in often contact with Matt at least once a week. So we're happy to handle that for you. Otherwise, I think that should wrap up our time for this call and this video. We will reconvene the first Monday of October at noon Eastern, 9 a.m. Pacific. Thank you all for joining us, and we will catch up with you next time.